back in action again. We're gonna switch a little bit. We're gonna talk about H80, an act relating to the Office of Healthcare Advocate. And our legislative counsel is going to come up and give us a walkthrough of the bill.
Hello again, Jen Carby from the Office of Legislative Counsel. We are looking at H80, an act relating to the Office of the Healthcare Advocate. And I put it up on the screen. All right, we're looking at H80, introduced by many members of this committee. And it amends several statutes as they relate to the Office of the Healthcare Advocate. They go through in numerical order through the title. So we start in Title 8 with filing and approval of policy forms and premiums. This is the major medical health insurance rate review, actually health insurance rate review generally. And there is an existing role for the Office of the Healthcare Advocate, but this expands that role a bit. Under existing law, the Office of the Healthcare Advocate can submit to the Green Mountain Care Board in writing, currently submit suggested questions about the filing for the board to provide to its contracting actuary, if any. This instead would allow the office to submit to the board in writing questions about the filing that the board shall ask the insurer, either directly or through its contracting actuary, if any. So it's making these not just suggested questions, but actual questions that the board must ask, and having the board ask the insurer either directly or through the board's actuary instead of just providing them to the actuary. Also changes what has to be made available to the public under existing law, with it not later than 60 calendar days after receiving an insurer's rate. Under the health insurance rate review section, the Green Mountain Care Board must make the insurer's rate filing, the department's analysis and opinion of the effect of the proposed rate on the insurer's solvency, and the analysis and opinion of the rate filing by the board's contracting actuary, if any. All of that has to be made available to the public. And then has the board post certain things on its website after redacting confidential or proprietary information. And this modifies that a little bit to have instead the board contemporaneously post on its website or otherwise make available to the public through a file sharing platform all materials in the record of a rate review proceeding after redacting any information or other material that the board determines to be confidential or otherwise subject to protection from disclosure by law. So it's a larger access to information. Section 2, now we're in Title 18, and this is in the Certificate of Need statute that you remember we looked at, or statutes that we looked at recently. So this is in the procedures and what the application process looks like. And under existing law, the Office of the Healthcare Advocate, and for nursing homes, the Long-Term Care Ombudsman is authorized but not required to participate in a review of an application for a certificate of need, and shall be considered an interested party in the proceedings after filing a notice of intervention with the board. That doesn't change. But again, there's expanding the scope of information that becomes available to the Office of the Healthcare Advocate and the Long-Term Care Ombudsman as applicable. So once either office files notice of intervention under existing law, the board must provide that office with the information necessary to participate in the review process, and includes certain information. Instead, this would replace that with once either office files a notice of intervention, that office shall have the right to receive copies of all materials related to the certificate of need. So it's not giving the board discretion to determine what's necessary to participate, but allowing the office to have access to all materials related, and also to ask questions of the board's employees related to the board's review of the CON application, submit written questions to the board for the board to ask of the applicant in advance of any hearing. And there's a typo here, it should say held, but my fingers apparently just type held because that's what I'm used to saying. Any hearing held in conjunction with the board's review of the CON application. And the office can submit written comments for board consideration and ask questions and provide testimony in any hearing held in conjunction with the board's review of a CON application. And then here we have this requirement that the Office of the Healthcare Advocate and Long-Term Care Ombudsman not further disclose any confidential or proprietary information provided to their respective offices. Section 3 amends the whole chapter in statute on the Office of the Healthcare Advocate. So starting at first change comes in section 9602, kind of an overarching statement that the Office of the Healthcare Advocate is established as an independent voice for Vermonters that is dedicated to promoting access to high quality, affordable health care for all. It maintains the language about the Agency of Human Services maintaining the office by contract with a nonprofit organization. It expands the language a little bit about the office administration. So in this case, instead of under existing law where it says the office shall be administered by the chief healthcare advocate, this says it shall be administered by one or more directors, one of whom shall be the chief healthcare advocate. So they could have more than one director, and I think you'll hear from them why. And also the director or directors are the ones who can employ staff and contractors as needed. Some of what's happening in 9603 is some terminology changes. So getting away from this idea of health insurance consumers, both because they work with people on issues beyond health insurance, and also I think some general aversion to referring to people seeking healthcare services as consumers. So this would have the duties of the office, first to assist Vermonters with health insurance plan selection, and by providing information, referrals, and assistance to individuals about means of obtaining, and this would add and paying for health insurance coverage and services, changing the term consumer to individual here. And again, health insurance consumers gets changed to Vermonters. Provide information to the public, agencies, legislators, and others about Vermonters' problems. So not regarding problems, but about Vermonters' problems and concerns regarding health insurance and this adds and access to health care. So again, broadening the scope a bit from a narrower focus on health insurance, because I think a number of the things you hear about from the advocate's office go beyond just health insurance. Identify, investigate, and resolve complaints, and this adds questions and inquiries on behalf of individual, and not just health insurance consumers, but individual Vermonters with respect to issues regarding health insurance, and it would add or access to health care, and assist those Vermonters with filing and pursuing more active complaints and appeals. Number 5, instead of providing information to individuals, it would provide consumer education to Vermonters, and it's not about their obligations, but their rights and responsibilities under broadening from just the Affordable Care Act to state and federal laws, rules, and regulations. Analyze and monitor the development and implementation of federal, state, and local laws, rules, and policies relating to, and not just patients and health insurance consumers, but relating to health insurance and health care, with a special focus on patients' rights and eligibility for state and federal health care programs. Instead of facilitating public comment, they will ensure policymakers hear directly from Vermonters by facilitating public comment on healthcare-related laws, rules, adding processes and policies, and striking language specifically about health insurers. Suggest, and this adds in some entities to the Green Mountain Care Board, Department of Financial Regulation, and other entities in state government, policies, procedures, or rules. So currently it's just Green Mountain Care Board. This makes it broader, that protect and takes out patients and consumers, and instead says that protect and promote the interests of Vermonters in matters related to health insurance and access to health care. not just promote the development of organizations, but collaborate with other healthcare and health policy related citizen and consumer organizations. Add to promote affordable and accessible healthcare for Vermonters. Ensure that, again, broadening beyond patients and health insurance consumers to all Vermonters, ensure that all Vermonters have timely access to services provided by the office. So change the date of the annual report from January 1st to January 15th of each year. And then some of this language changes, moves a little bit. So the Office of the Healthcare Advocate may, and under current law, this says, review the insurance records of a consumer who's provided written consent and requiring the insurer to provide them. There's some disclosure language comes a little later, but again, more broadly than health insurers. So they may pursue administrative, judicial, and other remedies on behalf of any individual, again, broadening beyond just health insurance consumers. So on behalf of any individual or group of individuals experiencing problems with health insurance or access to health care. Represent the interests of the people of the state, and in current law, it's just in cases requiring a hearing before the Green Mountain Care Board. This would instead say represent the interests of the people of the state of Vermont in matters involving healthcare and health insurance. And this is at the Green Mountain Care Board, adding the Department of Financial Regulation or other state agencies. Then in subsection C, just some language changes. So the healthcare advocate shall be able to speak to Vermonters and on behalf of the interests of Vermonters in healthcare and health insurance related matters. And then in subsection D, here's that access. So not just health insurers, but healthcare providers and health insurers shall cooperate with the office by providing relevant records and information when an individual or the individual's guardian or legal representative has authorized the office to act on the individual's behalf.
Jen,
Yeah.
can you just go back to place where it talks about, it uses the term Vermonters to describe individuals, and then it uses another word. You just went over it and I can't even find it now. I'm trying to find out what the difference is between them.
Oh, there isn't really. Sometimes it's just saying the same thing too many times. So we talk about individuals and Vermonters. I mean, technically an individual could be
Yeah.
from outside Vermont, other realistically.
Okay,
We're talking about.
so it doesn't make any difference. Okay,
I don't think so. I mean, we can look if there's a specific instance of concern.
okay.
All right, we're on page 9, duties of state agencies. This adds a new provision, new subsection A, in developing state policy affecting healthcare access and affordability. State agencies shall seek input from the Office of the Healthcare Advocate. This is a little change here, and under existing law, all state agencies shall comply with reasonable requests from the office. This would change that to say state agencies shall facilitate the office's meaningful participation in healthcare policymaking by complying with reasonable requests for information. And this also adds, in addition to information and assistance, it adds access. And a request shall be considered reasonable if it relates to the office's statutory duties and authority. More specifically, when appropriate, state agencies shall allow the office to access confidential or proprietary information that is otherwise exempt from public inspection and copying under the Public Records Act, and to participate in meetings, deliberations, and proceedings in which confidential or proprietary information is discussed. And it requires that the office not further disclose any confidential or proprietary information provided to it. Confidentiality strikes language, just sort of replaces language under existing law. It says, in the absence of written consent by a complainant or an individual using the services of the office or their guardian or legal representative, or the absence of a court order, the office, its employees, and contractors shall not disclose the identity of the complainant or individual. I think this, you'll hear from the office why they're proposing this change, but the proposed change would now say, the office shall maintain the confidentiality of information related to individuals using its services in accordance with all applicable state and federal laws, rules, regulations, and policies. Conflict of interest. There are existing provisions around conflict of interest on the employees of the office not having conflict of interest relating to the performance of their responsibilities. It talks under existing law about when a conflict of interest exists. This would add language requiring that the office report any potential conflicts of interest to the Agency of Human Services, and then specifies that it shall not constitute a conflict of interest per se for an employee or contractor of the office to serve without compensation on the board of directors of a nonprofit healthcare entity whose primary regulator is not an agency of the state of Vermont. And finally, Section 4, the act would take effect on July 1st.
Thank you, Jen. Any questions?
Most of your questions will probably be for the Office of Health.
None. Okay. So now we're going to turn the meeting, thank you, Jen. We're going to turn the meeting over to the chair.
Thank you.
Yeah.
Thanks for running things.
I was running, I'll tell you.
So I think we have first Brendan Atwood. Brendan, do you want to come on up?
Yes, and actually, Madam Chair, so I'd like to have actually
Oh,
John's join.
Absolutely.
Yeah.
Feel free to put your fish. Just a reason why I kind of move things around. It's my understanding that AHS has some suggestions, and so before we have the healthcare advocate up to speak to those, maybe we should find out what they are first.
Thank you, Madam Chair. For the record, Brendan Atwood, Agency of Human Services.
Ashley John, staff attorney for the Agency of Human Services.
So I'm actually going to hand it over to Ashley, who's going to be able to speak much more meaningfully and succinctly, I suspect, to these changes. They're really minor, and I do want to reflect that we did meet with the healthcare advocate team and the Green Mountain Care Blood legal team yesterday. I feel like we've got consensus on this language. So turn over to Ashley.
Thank you. Thank you for having me here today. I did provide a memo to the committee regarding what the changes we're proposing are, and I believe I can join the Zoom and share it on the screen if that would be preferred. If the Wi-Fi allows.
It's posted under Ashley in our.
So what we were looking at were the provisions surrounding the confidentiality and information sharing. And while we were very supportive of the Agency of Healthcare Advocate moving this rule into its current practice, reflecting current practices in the language, we just wanted to make sure that the language reflected all of the Agency of Human Services requirements, complied with HIPAA, ensuring Vermonters' information maintains confidentiality, running into issues of things like attorney-client privilege, executive privilege. So in an effort to solve for that, the phrase "to the extent permitted by law" got added in a few places. First in Section B, so it would now read, "States agencies shall facilitate the office's meaningful participation in healthcare policymaking by complying with reasonable requests from the office for information and access to the extent permitted by law. A request shall be considered reasonable if it relates to the office's statutory duties and authority." And then in subsection 1, we also added that phrase and made a few other changes. It would now read, "When a state agency deems appropriate, the state agency may, to the extent permitted by law, allow the office to access confidential or proprietary information." I also removed the reference to the Public Records Act for a few reasons. One, there are a variety of confidential and proprietary information that we would be dealing with. They're not all contained in the Public Records Act. there are also portions of the Public Records Act that this statute wouldn't allow us to waive, such as attorney-client privilege or executive privilege. So rather than having any confusion, I left it at only confidential and proprietary information. Similarly, in the section 9603D, we added the phrase as permitted by law, and added back in the option for written consent. In consulting with our department, in consulting with DVA, what we learned was there are still pieces of information within HIPAA that would require a written consent. So this allows us to share information, but when necessary, permits the insurers to request that written consent. I did note that when Jennifer was going through this rule, we were getting rid of the phrase consumer or the word consumer. So we could strike of the consumer and simply have this read, the provider or insurer may require written consent to share the requested records or information.
Can you just help me understand how it would work, when you say as permitted by law, so there's a request and then what happens?
So I think it depends on what they're requesting. But so right now, my understanding is that the healthcare advocate and DVA have a really great working relationship and a procedure in place where they share information. And their goal was simply to bring this up to current practices. There is certainly some information with health insurers, probably not so much with DVA, but with other health insurers where an oral explanation of this is the person representing me is more than sufficient to share information. There are, however, specific like Part 2 data, for example, that we keep that has to do with drug treatment or anything that falls into those bigger categories for confidentiality, where DVA would have to come back to the healthcare advocate and say, great, happy that you're working with this person, but we will need a written consent from that person before we can send you the information.
And what do you think the turnaround time would that be?
Great question. I think this allows them to not have to fall within requesting this as a public record. So it probably, if we have the information readily available, actually gets them the information sooner. If it's something that DVA has to compile, I think it would probably take longer. So whether it's an individual consumer or whether we're asking for a broad set of data is probably dependent on that answer.
Yeah, I'm thinking more about the individual because that's who I deal with. You know,
Sure.
someone who needs help and how do I get them help? And would that be a roadblock? And how do you think that timeframe might work?
Right. And I think now they're always required to get written consent. So this allows, if that's not something that's required, insurers to act without that written consent requirement. But when it is required and we have to protect that data with those specific requirements for HIPAA, this then just says we can come back and say, we need that written request.
Thank you.
Sure.
Mike, do you want to say something now or later?
And just say briefly, first off, we support this.
That's helpful.
The way it functionally works today from a provider, typically provider, is that somebody says, you know, I really gotta talk to the patient, and we get on the phone together. And the patient says, yes. And, but this is permissive. And so we support this, we think it accomplishes it.
Yes, of course.
Jen Carter, Minnesota Council. Is the concern about when it's required by federal law? This is law. Say in the law to the extent permitted by law, it's whatever we say the law is. Is it federal law that you're concerned about, HIPAA and Part 2 and?
Yes. And also if there's any conflict between this and things like attorney-client privilege, executive privilege that exists both in the Public Records Act, but also our obligations that, for example, attorneys have. An attorney can't waive that privilege, that it would have to be the client that waives the privilege before that kind of information could be shared.
I have to think about that. I would like to be able to say to the extent permitted by federal and to the extent not prohibited by federal law or something. I think we need to get more specific because this is just as much law as any other state law.
I think that makes sense.
And Jen, we'd be happy to work with you on that, of course.
Anything other than these language changes? Any thoughts on just H80 in support of all of it with these few little tweaks?
Yes,
Okay, great. Thank you.
thank you.
Michael? Yeah. Yeah. Yeah, on the screen.
Oh, I'm so screwed. I'm sorry.
There he is.
Hi.
Hi, Michael. Thanks for joining us today.
Yeah, thanks for having me. I'm sorry I'm not there in person, but I'm starting to feel a cold coming on. I didn't want to expose you all to
Well, thank you for that.
the. So for the record, my name is Michael Barber. I'm general counsel for the Green Mountain Care Board. Want to start by just acknowledging that the Office of the Healthcare Advocate plays an important role in the board's work, and we support the HCA's ability to meaningfully participate in that work. We did have a few provisions of this bill that we were concerned with, one of which you just discussed with AHS, and you know, we had concerns around just the breadth of some of that language, but we're good with the language that Ashley just presented, and with the modifications that Jen had mentioned there, that satisfies our concern with respect to that. The other provisions we had concerns with, the first one was on page 2. It's actually on page, sorry, it's on page 3, line 7. This whole section here deals with the board's rate review process and requires the board to contemporaneously post all non-confidential materials in a rate review case on the board's website, or otherwise make those materials available to the public through a file sharing platform, which is all fine, except for the word contemporaneously was problematic for us. So contemporaneous means kind of happening at the same time or during the same period. And it wasn't exactly clear what the posting needed to be contemporaneous with, but we assumed it was the filing of the information. In other words, we'd need to post materials on our website as they are filed, and that's just not feasible for us. We don't have like a publicly accessible electronic filing system like the PUC does or the court system does. So we have to post stuff on our website manually. We kind of beg and borrow from admin support within the organization to do that, and those people have other duties, and so it's just not possible to do that contemporaneously with the filing. So we would like that word stricken. We talked with the healthcare advocate about that, and they have no objection to that, is my understanding. The other piece we had a concern with was in section 2, which deals with the board's certificate of need process. Specifically on page 4, lines 8 through 9. This would give the healthcare advocate's office and the long-term care ombudsman's office a right to ask questions of board employees related to the board's review of a CON application. This whole section was kind of taken from the hospital budget statutes, it appears, and those processes are very different. So in the hospital budget process, the healthcare advocate is not a party. In the certificate of need process, they are a party, and we have rules against having one-on-one conversations with parties. And it would be problematic to have a party have a right to ask board employees questions about a pending application. So we propose deleting that subparagraph B1 there. Again, we discussed this with the healthcare advocate yesterday. They didn't have an objection to that. Maybe Mike could speak to that later. And that is it from us. I'm happy to answer questions about any of this.
And other than that, you're supportive of this, other than those changes? You're supportive of the whole of H80?
Yeah, we don't have any other concerns besides the ones I just discussed.
Great. Any questions from Mr. Barber? All right. Great. Thank you. Thanks for joining us.
Thank you.
Hope you feel better.
Thank you.
And Emily is.
Hi, good
How are you?
afternoon. Good. Thanks for having me. Emily Brown, Department of Financial Regulation. I'm the Deputy Commissioner. The department is supportive of H80 and the addition of the Department of Financial Regulation as an entity that's mentioned in this. And just to note, currently in our work, we often work with the healthcare advocate on issues, consumer issues and policy issues around health insurance. So we don't view this as a change to our current practice. We did have one comment. We don't have suggested language, but in the confidentiality section under 9605, and this might be a question for Jen, but we were wondering if this language could be strengthened in any way to ensure that when the healthcare advocate was receiving confidential information, it was required to treat it as the agency does or the department does from whom it's receiving it. And an example is all of our consumer complaint information is confidential per statute. And so we just wanted to ensure that if they were receiving confidential information, whether that was about a consumer or a health insurance company, that would have to be maintained in the same manner as the department would maintain it. So that was our only suggestion for any kind of language change or strengthening of the language. But aside from that, we support the bill, the rest of the sections of the bill as written.
Is that page 10,
Yes.
lines 6 through 9?
Yep, exactly.
Okay. All right. Well, thank you.
Yes, thank you.
And I'm sorry, did anyone have any questions for Emily? Thanks for joining us.
Thank you.
Would the healthcare advocate like to come up? Along with Charlie?
I'm gonna, Mike Fisher, healthcare advocate. I'm gonna sit here. I visited my grandbaby and I'm also now 100%. Give people a little bit of room and have Charlie testify. Thank you.
Thank you again for having me. Charles Becker, staff attorney with the Office of the Healthcare Advocate. Thank you for taking up H80 and thank you for supporting our office. So, I mean, I think the Office of the Healthcare Advocate was created, what, 12 years ago? Or the statute was written maybe 12 or so years ago.
In 98.
Oh,
Wow.
okay, even longer than that. Okay, right. So
The office was created, the statute is more recent than that.
Okay.
Because I wrote the statute.
The healthcare bulletins office. And then was updated in 2000.
2013 was when the statute was added.
Okay, so 12 years old, around 12 years old. And in that time, you know, the office has evolved. It's grown into the work that, you know, has been assigned to us. And really the main purpose of this bill is to update the statute to make it reflect the work that we do and the ways we serve the public and the ways we interact with state agencies. Jen did an amazing walkthrough. I don't want to repeat that, but I guess what I intend to do here is just to run through the bill again, but to try to speak more to why it's important to us as the Office of the Healthcare Advocate. So in section 1 of the bill, that amends 8 VSA section 4062, which is the rate review sections of statute, and amends the rate review sections in 2 ways. The first change is to change the section of statute to address the way the HCA that we're able to ask pre-hearing questions. So something to know about rate review, particularly qualified health plan rate review, is that it's a very formal process. It's almost like a mini trial. I don't even call it a mini trial. It's a full-blown trial. 2 days for, one for each of the health insurance carriers. And so it's a very formal process, and we are a party to those proceedings, right? We are we're not just a side participant, we're a full party to those proceedings. And our role in that process is to represent Vermonters, the people who buy health insurance, and we do that. We fulfill that role by cross-examining health insurer witnesses, presenting affirmative evidence of our own, and presenting argument about affordability and access of health insurance rates. As with any trial, there's a lot of preparatory work that goes into a trial, and that includes the ability to ask pre-hearing questions. In a civil legal system, that's called discovery. You have the opportunity to ask interrogatories, they're called. Currently, under the statute as it's written, we have the ability to suggest questions to the Green Mountain Care Board, which then the Care Board makes a determination about whether or not to pass some of those through, all of those through, or to even present revised versions of our questions. We think, that on some level impedes our ability to be a full participant in health insurance rate review. And so the language we're proposing here would change our right to suggesting questions to being able to outright present questions to the board that they shall then ask the insurers. We think that this, it would put us on a level playing field with the insurers and really enable us to fulfill our statutory role. I anticipate the insurers were not here to present their cases today. I anticipate that they have a different take on this language, and I mean, I guess, if there were one thing I might change, it would be to change the wording related to the filing and regarding the filing, and change it to something more like relevant to the filing. Related to the filing is not a legal standard. Relevant is. And so long as our questions are relevant to the proceeding, and it's determined to be relevant by the Green Mountain Care Board staff, we should be permitted to ask those questions.
On page 2, line 10, is that where I'm seeing you want the regarding changed to relating?
That is where I'm looking at. And granted, I'm testifying and my eyes are a little fuzzy here. But that word regarding is, I think the insurers actually are proposing, or might propose, directly related to the filing. And it's more that I understand. I feel like that language is problematic. What does directly related to the filing mean? Again, directly related is not a legal standard, but relevance is. So if we were to change that to relevance, I think that would be appropriate and workable for us. The second change to the rate review section of the statute is regarding transparency. Specifically, you heard Jen walk through the language. It would require the Care Board to post the entire record of a rate review proceeding to their website. I want to be very clear and upfront with you all. We think the Care Board is very good at transparency already. Any member of the public can follow a rate review proceeding from the time the rate gets filed straight through to when the board issues its final order. They post it right there on their website, and it's easily accessible for the public to see. So the board is already doing more than what's required by statute. The statute only requires them to post these specific things. The rate filing itself, DFR solvency opinion, the analysis of the board's actuary, and the pre-hearing questions and responses. That is not, it's close to being the entirety of the record, but it's not the entirety of the record. So this language we're proposing to substitute in here just makes it clear that the board should be posting the entire record of of a rate review proceeding. And to the extent that some documents are not being posted currently, it's our hope as the Office of the Healthcare Advocate that the board would post those documents. And so I do have some specific examples here in mind. And they relate to our ability to ask questions, right? So when we suggest questions to the board, current practice is for the insurers, if they have an objection to those questions, to submit written objections, which we then have a certain number of days to respond to, also in writing. And then the board makes a determination based on the objections and our responses about which questions to put forward. Currently, those objections and our responses are not being posted. What you see are our suggested questions, and then a couple of days, maybe a week or so later, you see the questions that get passed through. And it might not sound particularly significant, but from our perspective, it is. I mean, it's work that we're doing. It's work we're doing on behalf of Vermonters. Questions that we're asking for a reason, you know, because we think it's going to help us to develop our case. We think to the members of the public who are keeping track of these proceedings, it might be helpful for them to be able to see those documents too. And so that's, you know, again, they're very good at transparency, but not everything is being posted. And we think it would be helpful if these materials were being posted as well. So those are the changes to section 1, and yep. Contemporaneously. Yeah, that's right. Well, we agreed. Yeah, as General Counsel Barber stated, striking the word contemporaneously on line 7 of page 3 is absolutely fine with us. Any questions about the changes to the rate review section of statute in section 1? Okay, so moving on to section 2, the certificate of need section of statute. The current language here from our perspective is very vague. And it says essentially in reviewing a CON application, the Office of the Healthcare Advocate or the Long-Term Care Ombudsman's office, if we intervene, the board shall provide that office with the information necessary to participate in the review process. And even though it goes on to say, including all written correspondence and all entries in the record, because the language is silent on whether or not we get access to confidential information, it has been interpreted as not allowing us access to that information. And we've had to negotiate separate confidentiality agreements with certificate of need applicants to get access to those materials, which places a burden on the Office of the Healthcare Advocate in trying to obtain materials so we can review the application accordingly.
What line is that? I'm sorry.
Say that again, Representative.
I just wonder what line you're at. This, oh, he's received copies of all material. It's the all materials. That's you're referring to in line 6.
Yes. So currently it does say all written correspondence, all entries in the application record. That's in lines 4 and 5. But again, because it's silent on whether or not we get confidential materials, you'd think all would mean all, but because it didn't specifically specify confidential materials or address it, it's been interpreted that we don't have a right to access those materials. And you'll see that down in lines 16 through 19, that is where we include a specific reference to confidential materials. Any confidential materials were provided, we shall not further disclose. The language we're picking up here, as Mr. Barber from the Care Board said, is language that's copy and pasted from the hospital budget section of hospital budget review section of statute. That process, works well for us. I think it's a more contemporaneous statute. It was written more recently, so that's why we copied and pasted it here. But as Mr. Barber commented, sometimes when you copy and paste things, you have unintentional consequences. And one of the unintentional consequences here is that we had that reference in B1 of being able to ask questions of employees of the Green Mountain Care Board. And we agree that's not appropriate in the context of a CON where we are parties to the proceeding, which is different than our role in a hospital budget process. So we're comfortable with striking that language there. And so that is section 2, the CON section of statute. I'll pause if there are any questions.
Questions?
No? Okay, and that brings us then to section 3, which is the section of statute 18 VSA chapter 229 that creates the Office of the Healthcare Advocate. This is the statute. As Ms. Carby said, many of these changes here are cosmetic, for example, changing health insurance consumers to Vermonters, using more humanizing language. But other changes here are more substantive. But again, they don't expand the duties of our office. They're more bringing the statute into line with current practices and what we're doing on behalf of Vermonters. So I'll quickly run through some of the more important ones from our perspective. 9602A gives us a mission statement to be an independent voice for Vermonters dedicated to promoting access to high quality, affordable healthcare for all. 9602C reflects the work that is currently being done by two co-directors. We have a chief healthcare advocate, but we have two co-directors. Marjorie Stinchcomb, who's primarily focused on the helpline, and Mr. Michael Fisher, who is, he has some work on the helpline as well, but he's primarily policy focused. The changes here would reflect that sort of co-directorship structure. In section 9603, duties and authority, this is what you, the legislature, are directing us to do and allowing us to do. One theme, as your leg counsel pointed out, is to change to reflect that we do more than help Vermonters with health insurance issues. We help them with access to healthcare issues. So you'll see that language in paragraphs A3 and A4. Similarly, we do more for Vermonters than help them with Affordable Care Act policy questions. We help them to understand their rights and responsibilities under all manner of state and federal laws relating to healthcare. So you'll see that language there at A5. We do more than just advocate for Vermonters before the Green Mountain Care Board. We advocate for Vermonters before any state agency that's touching upon healthcare policy, including the Department of Financial and Regulation, which is why we specifically call them out here in paragraph A8. To the extent there are questions about the repeal language at B1, I believe that was regarding access to insurance records of people seeking HCA services. That language was rephrased as indicated and is now at paragraph D at the bottom of page 8. And we agree, as has been stated, with AHS's revisions to that language. Section 9604, duties of state agencies. The revisions here. The existing language, in our opinion, is rather meek. All it said in existing language is state agencies shall comply with reasonable requests from the office for information. And so we've taken that language and expanded it to reflect how the HCA and state agencies currently work together to develop healthcare policy on behalf of Vermonters. First, it says at subparagraph A that agencies shall seek input from the HCA when developing health policy, which they currently do, but this puts it into writing in statute, that practice. At subparagraph B, we say not only should agencies seek input from the HCA, but they should allow us to help them in a meaningful way by providing us with information, even confidential information if it's appropriate, and allowing us to sit on meetings, even meetings where confidential information is discussed. Again, with the language revisions suggested by AHS being okay with us about, to the extent consistent with applicable law, allowing us access to that confidential information. Lastly, I'll touch upon the conflict of interest language at 9606. That one has been little remarked on. The major substantive change here to be to allow an HCA staff person the ability to serve on a board of directors of a nonprofit healthcare entity whose primary regulator is not the state of Vermont. Currently, under the statute as written, it creates a conflict of interest for an HCA staff person to be on the board of directors of a healthcare entity. This opens that up and says it's not a conflict per se for an HCA staff person to be on the board of a healthcare entity, so long as it's in a non-compensated role, and so long as the regulator of that entity is not an agency of the state of Vermont. And there's a very specific example here I can give you. I was given the opportunity to join the board of directors of the Rutland FQHC, and we spent a good, I want to say 6 months going around talking about whether or not this was an appropriate thing for me to do, a permissible thing for me to do. Ultimately, we decided it was okay, despite the language and statute. This would sort of clean that up and make it absolutely okay. And also, I would just say in general, nonprofits, they need board members and HCA staff members, could potentially be good board members. And so this would open up that possibility for them.
And I'll chime in. And we talked to the agency, as contractors, and as much as we could about this decision. And the one other thing to add is that it's also, I think, good for the HCA. This is different because the VPQHC is not a provider, but I'm also on the board of VPQHC. Another nonprofit that could have a policy role that's different from policy that's in the HCA. But I think it's good for in addition to it being good for the FQHC to have Charlie on, I think it's good for the HCA for us to gain these kinds of insights that you get from being.
So that's all the testimony I had. If there are any questions, of course, I'd be happy to answer them.
Any questions? Pepper.
If one. I don't know what section it's in, but it talks about co-directors.
Mhm.
And it says, it doesn't say, it says co-directors. Does that mean it will never be more than two?
I think that was our intention. Yeah. I'd have to go back and read the language to see if I
It says director or
Director, so it leaves it permissive. And I would just say, one of the first things that sort of structural changes we did after I moved into the chief healthcare advocate role was to recognize that that I really had a co-leader and an equal co-leader. And so moving that, so, FYI, I'm the guy who shows up and talks to the press and comes to committee meetings and calls himself a chief healthcare advocate. But operationally, how we run the shop, we have a co-directorship with shared decision-making for what we do.
Any other questions? So we've heard from DFR, we've heard from Green Mountain Care Board, we've heard from AHS. We've yet to hear from the insurers, and I know that we will. But do you think that there are concerns, and how would you sort of address their concerns? I think we've received some written testimony on it. And what would you say?
I think we should hear from them, and I think and I would not be surprised if I haven't read their testimony, but I wouldn't be surprised if they had concerns about our ability to ask questions. But I think Charlie put it well. Our position is that we have to be able to develop a case, and that does, you know, and I'll say it more extreme, in a more extreme way. You know, we're the public's advocate in this proceeding, and if, you know, don't send the public's advocate into the ring with an arm tied behind her back. If we can't ask questions, we can't develop our case, we can't argue the case. So, and the other thing I'll add, because I'm not sure it's been said, I think for 2 years now, what is said in the statute is actually what is practiced. The Green Mountain Care Board, its current leadership, has been passing on all of our questions unedited. We've got stories from the past, which I don't need to do now, but of questions not being asked or edited in such a way that it was no longer our question. So we think it's important.
Could I add one more thing to that as well? Because I was here in my handwritten notes and I didn't say it. That, I mean, I think from the health insurer's perspective, I've heard them use language. They want our questions to be directly related to the filing. And I think in their mind, that means actuarial questions. But health insurance rate review is more than an actuarial review of the rates. There are statutory criteria, including whether or not the rates are affordable and promote access and quality. So a lot of our questions are trying to elicit information about affordability, access, and quality. So it's important for us to be able to ask those questions as well.
And you're recommending regarding be changed to relevant.
Yeah, I mean, that would be the simplest change. If it comes to needing to come up with compromise language, believe me, I have some language ready to go, but I don't know if we're there yet.
For the moment, I think we should say, we think that change makes sense. We're gonna stick to our guns.
Right. Leslie, go ahead.
Say that kind of phrase. That's like a no-no phrase. We're gonna hold our position.
Yeah, I think that also might be a phrase if you analyze that one a little bit also. I mean, Leslie.
So I'm interested in your mission statement, I guess it's beginning of section 3. Could you just use the language, the public's voice, as opposed to an independent voice? And to me, that means different things. And I feel like the public's voice is a stronger, but that may be not, that's just my language, I'm not sure. But you're representing the public as opposed to Green Mountain Care Board or AHS, because I'm trying to look at all the different players here and trying to understand who's getting represented. So I'm just wondering about that.
Well, I like that a lot. If I could chime up here. I think the reason why we use the phrasing an independent voice for Vermonters is because I think some Vermonters think we're a part of state government. We were trying to express that we're separate from state government. So maybe there's a way we can say both.
Well, that would be great, because
Yeah.
I watched enough Green Mountain Care Board meetings to hear your voice in that room. And that is the public's voice. And who else is representing that voice aside from you? So that.
And I think it's important to say, everybody believes they're representing the public's.
I knew that someone was going to say that, like Brendan over there, but it's-
I mean, and you know, I mean, the Green Mountain Care Board certainly has a representing the public's role, and you know, and insurance carriers representing the public voice of their policyholders, and so on. We just have a bit of a different vantage point.
well, that's what I'm feeling, that your vantage point is not hamstrung, for want of a better term, by others.
Okay, any other questions? Right?
Thank you again.
Thank you.
Thank you.
I think we're actually done for the day, are we not? Yes, we are done for the day. So we're back here tomorrow morning at 9 a.m. And we're gonna go back to preventing workplace violence. I keep calling it workplace violence, but we're trying to prevent it.